Please subscribe the channel and hit the bell icon for the future uploads. Hello everyone. In this part of the video, we are going to see the provisions relating to custody of children in Divorce Act 1869. So, on this topic, what will be the questions asked in the question paper are: describe the various provisions for custody as far as Divorce Act 1869 is concerned, or in which provisions of Divorce Act custody is granted. Questions asked: what are the provisions for child custody in the Divorce Act 1869? Second, what are the factors to consider while granting custody of children under Divorce Act 1869? This question can be asked in a short note or for 8 marks, but never for 16 marks. It is not a lengthy question, but there are various provisions of law involved and therefore it can be asked for 8 marks. So while writing this, we have to write first the synopsis, wherein it will cover introduction part, what the custody is, when it can be granted by the court, what are the various provisions of Divorce Act wherein custody of the children can be granted, interim custody, permanent custody, difference between the two, then maintenance order of the children, modification of custody orders already granted in the proceedings, in which proceedings it can be granted, and then the conclusion part. So first of all, we will see what custody is. To introduce the topic, we can say that when parents are being separated, as far as the child is concerned, child can stay only with one of the parents, and the other, if wishes to have the custody of the child, they can approach the court and say that no, I want the custody of the child because I am a better parent than the other, I can look after the child in better ways, and so custody of the children can be asked in the court. Now what are the various provisions of Divorce Act? You must have seen that Indian laws wherein there are various marriage acts, and Hindu Marriage Act there is only one section, Special Marriage Act there is only one section, but if we see Divorce Act, there are altogether 4 sections or 5 sections wherein custody is elaborately discussed. So there are various sections to deal with custody, and the sections are divided as per the reliefs asked by the parties. So the topic is divided amongst judicial separation case or divorce or nullity case. So custody of children can be sought in either judicial separation case or divorce or nullity case. First we will see judicial separation case. In section 41, the law or Divorce Act states that in a case pending for judicial separation before the court, an application can be made to get custody of the child or for maintenance of the child or for other expenses of the child. So all these 3 grounds, education expenses for that matter, are also covered under the section 41. So there are various factors to be considered to grant a custody, but basically there has to be a petition pending of judicial separation to get custody under section 41. Then the order is interim or permanent granted by the court. That order can be modified as per section 42. That is, if the order of custody is granted in section 41, it can be modified by order under section 42 of Divorce Act. Also, wishes of the children are of paramount consideration while granting the custody, and there are various other factors. We will see the factors in the later on of this topic. So this is what section 41 and 42 speaks about as far as case of judicial separation and then asking for the custody of children. Custody of children, section 41, in case of judicial separation, has to be filed in the proceedings of judicial separation pending under the Act, can be made by the spouse wanting custody of the children. Wishes of the children are taken into consideration while granting the order. Order can be passed interim or permanent in this section. Maintenance for the children also can be granted under this section. Order of custody can be modified from time to time due to change in circumstances as per section 42. So when the petition is filed for divorce or nullity, under section 43 of Divorce Act, it deals with the custody application to be filed in divorce or nullity proceedings. So if the proceedings for nullity or divorce are pending before the court, the parents can seek custody from the court. Again, there are various factors to be considered by the court, but there has to be first of all a petition of nullity or divorce pending before the court, then only custody application can be made. It can be permanent or interim. the custody can be modified from time to time by making an application under section 44 of Divorce Act. And there are basically wishes of the children also are taken into account while granting custody. Now we will see what are the various factors wherein custody order can be granted. But first of all, we will see section 43 and section 44. Custody of children, section 43, in case of nullity or divorce, has to be filed in the proceedings of nullity or divorce pending under the Act, can be made by the spouse wanting custody of the children. Wishes of the children are taken into account while granting the order. Order can be passed interim or permanent in this section. Maintenance for the children also can be granted under this section. Order of custody can be modified from time to time due to change in circumstances as per section 44. Now we will see what are the various factors while deciding the issue of custody of children. First of all, first and foremost part is wishes of the children. That is given a paramount consideration while dealing with the issue of custody as to where the child wants to reside. But that is not the only ground. There are various grounds. Then financial capacity of a person to maintain the child. Then who can give better time to the child. If a father is working for 12 hours and mother is a housewife, definitely mother can give a better time to the child, and father can visit the child, or father can have access of the child during the vacations like Saturdays and Sundays. If he has holidays, he can be with the child during that time. But for the entire week, the child can be with the mother because she can look after the child in better ways. Then who can tell the child better ways, like if the child is attaining puberty and it is a male child, of course father can discuss the issues of puberty with the child in better ways. Similarly, if it is a daughter, then mother can speak as to the changes in her body in a better sense than that of a father. That also is considered while granting. Also, what are the other, like where the person is residing. If the person, rather mother, is residing in a village and the father is residing in a city area, what are the other amenities which are better available for the child also is seen. So there are various factors. As far as maintenance is concerned, while granting maintenance also it is seen that what are the needs of the child, and then maintenance is granted as per the standard of living of the parties and as per the needs for the child. But moreover, this right of custody is to be considered more of a right of a child than that of a parent. So we don't consider the right of custody as a right of a parent, but a right of a child, because child has a right to be with both mother as well as father, and that's why we see entire topic of custody through the point of view of a child and not of a parent. Factors to be considered while granting custody orders. Many factors are considered while granting custody of children. A. Wishes of the children. B. Financial capacity of the spouse to look after the children. C. Where is the spouse residing, keeping in mind the better prospect for the child. D. Who can look after the child in better ways. E. Whom the child is most comfortable with while spending time. This is considered more of a right of children towards the parents than the other way around. So even if this is a short length question, still we have to write the conclusion as well. The conclusion helps the examiner to understand that you understood the topic well, to give you better marks in the answer sheet. In the conclusion we will write that custody of a children is more of a right towards the child than that of a parents, and there are various factors to consider while granting custody, and in cases of judicial separation, divorce or nullity, the custody can be sought by the parents in the court. Custody can be interim or permanent, and it can be modified from time to time. While deciding custody, maintenance of the child also can be granted. So these 6 or 7 lines contains the gist of the entire answer, so that the examiner will know that you know the topic. By going through the synopsis and going through the conclusion, he will understand that you have written the answer properly and he will give you good marks. The same video in Marathi language is also uploaded on YouTube, link of which is given in the description box down below. Please follow the same. If you have liked the video, please give a thumbs up. Video on various topics are going to be uploaded on YouTube. Please subscribe the channel and hit the bell icon for the future uploads. Thank you.